agenda for the next 2 years. But today, we still continue to focus on what we have left to do within this budget cycle for this year.
Right.
And there's a lot of exciting things happening there. We'll continue on with our efforts in the e-government side of things. We've had some tremendous successes in the guest registration at the Department of Vehicle and Driver's Licenses. We have had some good uptake on that. I recognize that the issues with the old system we had was that you had to appear in person to receive an electronic ID called an ECID before you could start to use the program. So we've created a guest program that you can go on, be a one-time user and renew your driver's license or renew your vehicle registration. And we've had tremendous uptake in that. So we're extremely pleased with that. The other big success we've had has been with the Department of Commerce and Investment, trade and business licensing. You know, we did a review of that. We reduced red tape by some 65%, and in doing so, we were able to put all of the application process online. You can do it by your mobile phone or by computer. You can apply, you can renew, you can pay for everything. You can do it 100% online. We've had fantastic uptake in that. And I am happy to report that on the Deputy Governor's rate your experience, they just received a 100% satisfaction rating in the last report. So congratulations to them. That is a testament of some of the efforts being done in that department with their online services and, of course, being generally helpful over the counter as well. We are excited as we move into the next phase of our National Development Plan. The law requires that we review the National Development Plan every 5 years, but unfortunately this has not been done since 1997. So this was a priority of mine, a priority of our ministry, that we wanted to be compliant with the law, and we saw the importance of planning for the future as we go through this building boom we have. So
I will now call the Honourable Premier to say prayers.
Let us pray. Almighty God, from whom all wisdom and power are derived, we beseech Thee so to direct and prosper the deliberations of the Legislative Assembly now assembled, that all things may be ordered upon the best and surest foundations for the glory of Thy name and for the safety, honor, and welfare of the people of these islands. Bless our Sovereign Lady, Queen Elizabeth II, Philip, Duke of Edinburgh, Charles, Prince of Wales, and all the royal family. Give grace to all who exercise authority in our Commonwealth, that peace and happiness, truth and justice, religion and piety may be established among us. Especially we pray for the Governor of our islands, the Premier, the Speaker of the Legislative Assembly, the Leader of the Opposition, Ministers of the Cabinet, ex officio members, and members of the Legislative Assembly, that we may be enabled faithfully to perform the responsible duties of our high office. All this we ask for Thy great name's sake. Let us say the Lord's Prayer together. Our Father, which art in heaven, hallowed be Thy name. Thy kingdom come, Thy will be done on earth as it is in heaven. Give us this day our daily bread, and forgive us our trespasses, as we forgive those who trespass against us. And lead us not into temptation, but deliver us from evil. For Thine is the kingdom, the power, and the glory, forever and ever. Amen. The Lord bless us and keep us. The Lord make His face shine upon us and be gracious unto us. The Lord lift up the light of His countenance upon us and give us peace, now and always. Amen.
Please be seated. Please be seated. Proceedings are resumed. This Honourable Legislative Assembly is now in session.
Administration of oaths or affirmations.
None.
Reading by the Honourable Speaker, messages and announcements.
Honourable members, there is a grave and most serious matter that will give rise to a statement by the Honourable Premier this morning and a request for adjournment of this Honourable House to debate a motion that bears on the matter of our constitutional position as Honourable members of this House. I'm herewith proposing that we do not proceed at this point with the order paper as is, because of this matter is such one of national import. We should deal with the Premier's statement, take it from there to deal with the motion that I have been made aware of. That will be done after I have delivered this message. Honourable members, since Friday last, in the most basic form, questions were asked of me that really only required three options: yes, no, or ignore. I've had many of those same kind of sentiments and numerous messages sent to me during the ensuing days, and I choose not to respond then. Not because I was comfortable with any belief, but more of me analyzing the gravity of the Honourable Chief Justice's decision. Did his decision change me when I woke up yesterday or today? No, it didn't. It also meant that my core principle and beliefs that I was brought up to believe did not change either. That is, that marriage is between a man and a woman. And that is my constitutional position as an elected member to make laws and change laws is only and only the purview of this elected body, this Legislative Assembly. Personally, I do not support a lifestyle that says marriage can be between man and man or woman and woman, and I won't pass judgment on anyone that does, but also don't castigate me because I indicated this belief. Neither am I here to hurt any family's feelings. I have moms and dads who are my genuine friends. I too have family that I love. If I know that one of my kids or any family member or my friends was in an alternative lifestyle, it would not allow me to love them any less than I do now. But the lifestyle itself would not be something I would support. Honorable members, this ruling to allow marriage of any sex is dividing our country, dividing our family, and dividing our friends. We, as honorable members of this House, cannot allow that to happen, as while there should or might be legislative changes to be made, can be made to further ensure or buttress our position that marriage is between a woman and a man, and is the law made by the Legislative Assembly of the Cayman Islands. I don't think the Honorable Court can legislate at all, but particularly so, it cannot legislate my intent or the intent of any legislator, so the law passed by the Legislative Assembly is the law of the land, and we must respect it. Throughout my political career, spanning at least 50 years of solid knowledge, be careful what I'm saying and be careful what you're hearing. I'm not saying I've been elected for 50 years, but I have been involved that or longer. These social issues have been knocking around. In those years when I had executive authority as leader of the government, this matter, this issue was shoved in my face. And I was threatened and I was warned by the then Minister Chris Bryant that I should be supporting the United Kingdom and keeping its international obligations on human rights to what is expected of them, and that as a United Kingdom overseas territory, I was obligated to do so. Well, I told him only over my dead body. His response, there are many dead political bodies, and I had better understand that I would not stand in the way of the United Kingdom. Then, in June or July 2012, I was pushed by the then Minister Mark Simmons to support beneficial ownership on the social issue of same-sex marriage and civil unions, and finalize the law to give the United Kingdom FCO powers over government projects. Three things. I refused, and I told him and the Treasury Minister that I would not support the change of our laws to allow the social issues, and as far as beneficial ownership was concerned, they didn't have any legislation themselves, nor did I know of any of our competitors who had any. And I had left my pen home. I also told Mark Simmons that I would support the law on projects, finally, but I was going to put in an amendment that said that if the United Kingdom gave me a decision that ended up with the Cayman Islands losing business or costing us money, the United Kingdom would have to stand the cost. Well, that only incensed the minister, Mark Simmons. The minister said, and I quote, I was a stubborn, troublemaking premier, and I would put my government in more problems and things would be bad for me. The United Kingdom, he said, would not be dictated to by its overseas territories. Well, I was determined as sworn as the premier to protect this country, and I knew then that the die was cast for McKeever Bush. That was Thursday. And the next Tuesday morning, they walked into my house, my living room at 7-ish a.m. with a trumped-up charge of theft. With the ugliest people I saw in my life at my front door. My grandson was discombobulated as he came out of his bedroom. My wife fell on the floor, and they went through my wife underclothes in our bedroom and threw them on the floor, searched and searched until 4 p.m. that evening, and only carried away books with a trumped-up charge of theft. And honorable members, you know the rest. There were those who said, lock him up, kick him out, because he wants independence and is disrespectful to the United Kingdom and only wants to cause trouble. There is today still circulating messages to me, misinformation. Even this morning, 7:23 a.m., is telling us that this House is seeking independence today. This is the kind of misinformation that we must quell today. I have been in politics a long time, and the wannabes out there have smelled blood. I have recounted that horribleness this morning to tell those of my adversaries who have now been saying over the last few days, since Friday, that it is McKeever and Alden's fault. I'm here to tell them, oh, no, you don't. Not because I'm the speaker am I going to sit back in this chair and allow the wannabe MLA to spread the gossip and tell more lies on me or the premier or any member that I can swear for of this honorable House. But above everything else, I won't sit back as an elected member because I am the speaker and ignore the matter before us. If you're looking at rights, well, I have my rights too. And I have fought for my country when I thought our way of life, as we know and were raised by parents, me by my mother, and the premier by his mother and father, was being threatened, and our financial industry stood to be severely curtailed. I fought then, I stood up then, and I will do no less now. As I proposed, or as is proposed, you will hear from the Honourable Premier, and you will hear from the senior members of this Honourable House, the member from East End, and the member from Savannah very shortly. Later, I can guarantee you that you will hear from those who oppose me, who get on the radio shows and say that I don't do right as the speaker. But I have a right, as a duly elected representative of the people, specifically from the constituency of West Bay West, to have my say. That is a real human and constitutional right, and no one or any law or otherwise can take that position from me until the people of West Bay West say so. You can move me as speaker, but only one of you in this House can vote for me. 2. These are matters of grave import, and we must deal with them now. The matter, honorable members, is in our hands. And may I tell the so-called constitutional experts on everything, on radio shows and the biased press, if you can call the blogs that, they do not enjoy the will of the people as an elected representative, and they never will. They don't know of the nuances of being the speaker and won't ever enjoy being criticized of being the Honorable Speaker of the Legislative Assembly. So, correct. Better than that, they can be like the castrated ram cat who sits on the fence all the time, every night, only to give advice which all know to be invalid. I will call on the Honorable Premier to move suspension of standing orders. Honorable members, this is a matter of grave import.
Mr. Speaker, I beg to move a motion that the business of this House, as set out on the order paper for the day, be rearranged in order that I may make an important statement in connection with the judgment of the Honorable Chief Justice, and that following that, we are able to permit a private member motion to be brought by the member from East End and seconded by the member for Savannah to be dealt with. Mr. Speaker, we would also then require the suspension of Standing Order 24-5 in relation to waiving the notice normally required for private members' motions to be dealt with. But, Mr. Speaker, for clarity, if I might put the first motion, that is that the order of business be rearranged to permit the making of a statement immediately following your address, and then proceed to deal with the other standing order thereafter. And so, Mr. Speaker, I move that in accordance with Standing Order 14.1, that the order of business be rearranged on the order paper to permit a statement being made by myself, followed by the taking of a private member's motion in precedence to the other business on the order paper.
Question is that the Standing Orders 14.1, firstly, be changed to allow the business to proceed that we have recommended. All in favor?
Aye.
Those against? The ayes have it. Honorable Premier.
Mr. Speaker, I now move the suspension of Standing Order 24-5 in order that a private member's motion to be moved by the member from East End and seconded by the member from Savannah be dealt with today and in precedence to other business.
Allow it. Question is that business paper be changed to allow Standing Order 24-5 to come in to play to allow the private member's motion. All in favor?
Aye.
Those against? The ayes have it. Honorable Premier.
Thank you, Mr. Speaker. Yesterday, April 2nd, 2019, the Cabinet of the Cayman Islands instructed the Honorable Attorney General to pursue an appeal against the judgment of the Honorable Chief Justice Anthony Smelly, QC, handed down on 29th of March in Civil Cause number 111 of 2018 and Civil Cause 118 of 2018, otherwise known as the same-sex partnership case. The Honorable Attorney General was also instructed to seek a stay of execution of the judgment pending the outcome of the appeal. Mr. Speaker, as you have indicated, you, like me, and indeed all of us in this House, have received many telephone calls, WhatsApp and text messages in the days following the handing down of the Chief Justice's judgment, asking what government intended to do regarding the judgment. Mr. Speaker, there were those who sent messages stating that they feel the outcome was right. There were many more that sent messages stating they feel wronged by the decision and made clear in no uncertain terms their view that marriage should remain the exclusive domain of heterosexual couples. And there were also those who, regardless of how they feel about the concept of same-sex marriage, expressed shock and disbelief that the court could have made such a fundamental public policy change in a matter as important as the institution of marriage without reference to this legislative assembly. Mr. Speaker, we were also peppered, and still are being peppered, with requests from the press asking for a statement. However, as the Honorable Attorney General stated after the judgment was handed down, the ruling required careful consideration by government. And so the government has taken the time to consider in its caucus and the cabinet to take legal advice and to discuss this most important matter and its implications. I want to add here, Mr. Speaker, that I and my entire government have great respect for the Honorable Chief Justice and indeed the independence of the judiciary. But even the best judges get it wrong from time to time. Hard cases make bad law. None of us who are human are infallible. Mr. Speaker, the government believes that in his determination to right what he has described as injustice and indignities suffered by the petitioners in the same-sex partnership case, the Honorable Chief Justice may have exceeded the scope of the powers conferred on the court by the Constitution, and in doing so, some have argued, assume the role of this legislative assembly in deciding on what should be public policy and then legislating for it. Mr. Speaker, the government is cognizant of the provisions of Section 5(1) of the Constitution and the mandatory requirement imposed by that section that all existing laws, quote, shall be read and construed with such modifications, adaptations, qualifications, and exceptions as may be necessary to bring them into conformity with the Constitution, unquote. But we believe that introducing the entirely new concept of same-sex marriage into the existing marriage law goes way beyond any reasonable interpretation of modification or adaptation. This, we believe, might be inconsistent with the separation of powers by trespassing on the constitutional remit of this legislative assembly. Mr. Speaker, I spent much of the first 8 years of my political career on both sides of this House engaged in the efforts to get us a modernized constitution. The previous constitution order was made in 1972, and we had outgrown its provisions, and a new constitution was desperately needed to catch up with our growth and development as a country. As early as 2001, the United Kingdom government made it clear to us that no constitution would be agreed that did not contain a Bill of Rights. On the other hand, Many stalwarts in this community, and especially religious leaders, were concerned about the implications for the traditional institution of marriage of a Bill of Rights, and in particular, what is now Section 16 of the Bill of Rights in our current Constitution, which prohibits discrimination on a number of grounds, including sexual orientation. Mr. Speaker, it was plain to the government at the time that we would never get the new Constitution approved by referendum unless we were able to satisfactorily address these concerns. So, Mr. Speaker, we invited representatives of the Cayman Ministers Association and the Seventh-day Adventist Conference to not just discuss the proposed new Constitution with us, but to actually be part of the negotiating team, not just here in Cayman, but at the final round of negotiations at Lancaster House in London as well. Mr. Speaker, the genesis of Section 14 of the Bill of Rights in the Constitution, which was described by Sir Geoffrey Jowell, who led the government's team in the case, as the rock of the government's case, was the concern, the genesis of that was the concern by the religious community in Cayman to ensure that the institution of marriage, which Christians believe to be God-ordained, remained available exclusively to persons of the opposite sex. Thus, Section 14.1 provides, quote, "Government shall respect the right of every unmarried man and woman of marriageable age freely to marry a person of the opposite sex and found a family," unquote. These words are deliberate and were intended to provide the necessary assurances to the Caymanian community, but in particular the Christian community, that the institution of marriage would retain its traditional definition as the union between one man and one woman. To ensure that there was no question about this, in tandem, this Legislative Assembly amended the marriage law in 2008 to define marriage as, quote, "the union of a man and a woman as husband and wife," unquote. Mr. Speaker, I have no doubt, given my intimate and lengthy involvement with these issues during the constitutional discussions, negotiations, and amendments, that without the assurances of Section 14 of the Bill of Rights regarding marriage and the amendment to the marriage law in 2008, that the 2009 Constitution that we now operate under would never have been approved on referendum. I also know that the constitutional discussions and drafting did not contemplate that Sections 9, 10, or 16 of the Bill of Rights that deal with private and family life, conscience, religion, and non-discrimination would apply to marriage. Hence the reason why marriage is in its own separate place in Section 14 in the Bill of Rights. As the government submitted to the Honorable Chief Justice during the hearing of the case, Section 14 is the constitutional provision that specifically provides for the right to marry. It is what the lawyers call the lex specialis. That is, the part of the law that governs the specific subject matter of the institution of marriage. Mr. Speaker, the current Constitution is a comprehensive, negotiated document, the result of 8 years of extensive consultation across the various demographics of the Cayman community, often bitter political differences, and very difficult negotiations with the Foreign and Commonwealth Office. It was then approved by the democratic process of a referendum. It is not something that was dreamed up by the Cayman government. The document strove to represent the strong feelings of the Caymanian community, in particular as regards the institution of marriage. Given the highly controversial and landmark ruling by the Honorable Chief Justice on March 29th, if left unchallenged, the implications for the Cayman Islands Constitution are significant and potentially far-reaching and go well beyond the rights of same-sex couples. While a challenge to the ruling is certainly not a decision to be taken lightly, given the important human rights concerns raised in the case, the ruling of the Honorable Chief Justice has brought about significant ambiguity surrounding the Constitution and Bill of Rights, and the interpretation of and the ability of the court to amend other laws should similar applications be made. Based on the executive summary of the court's judgment, there are three main points of concern which we have identified, and the government, as well as men in this House, I know, share those concerns at this initial stage. I should add, Mr. Speaker, that the full judgment has not yet been published, and there may well be other grounds or that raise concerns once we have had a chance to analyze the full judgment itself. But thus far, Mr. Speaker, firstly, the implications of the court's decision for other types of marriages, for example, polygamous marriage, and whether government would now be bound to give effect to or recognize such marriages if an application for a marriage license is made by a man or for a man to marry multiple wives. Mr. Speaker, the second concern relates to the extent of the powers of the court under Section 5(1) of the Constitution to modify legislation on matters such as the right to marry, bringing into question the appropriate separation of powers under the Constitution, and whether by exercising these powers under Section 5(1), the court has exceeded its mandate under the principle of separation of powers. A third concern, Mr. Speaker, is whether, given the language in Section 14(1) of the Constitution, it was open, that is the section, Mr. Speaker, that carved out marriage as an institution between a man and a woman of marriageable age only. Whether it was open to the court to find that the right to marry and found a family could be located in other rights within the Bill of Rights, namely sections 9 and 10 of that document. Mr. Speaker, after very careful consideration of the three main points previously mentioned, the government is of the view that the issues are of fundamental constitutional importance, and therefore it is in the public interest to have them considered and determined by an appellate court. For clarity, I will add that the appeal will not be pursued in the name of the governor, but as is usually the case in actions by or against the government, in the name of the Attorney General and the actual office that made the decision. Mr. Speaker, let me say here that in appealing, the government is cognizant that there is no guarantee or certainty as to how the Court of Appeal will rule. However, we believe it is critical that the country has the benefit of clarification on these very important constitutional issues. I wish to note that I am painfully aware that the issue of same-sex marriage is an emotive one in our islands. I am also very conscious that this is an issue with real people who have real lives and there are emotions and feelings involved, and that this is not merely some textbook case. I and the government have no intention of causing any harm or hurt to the petitioners, but we must ensure that in seeking what they deem protections and rights under the law, that a door is not opened that may impinge upon other protections and rights. As Premier, I will state again what I have said many times before. I have no doubt that the feelings of the majority of Caymanians are that marriage should retain its traditional and religious definition and meaning, the union of one man and one woman. I recognize that many of the younger generation of Caymanians have differing views on this issue, and it is quite likely that in years to come, the majority view of Caymanians may change. But such a majority is not evident to any of us here today. However, I equally want to make it clear that no matter what my own religious beliefs, or indeed the beliefs of the other members of my government or of this parliament, as Premier, I also have an obligation under the law and the Constitution, and indeed given my religious upbringing under the teachings of Christ, to ensure that all people, but especially any minority group, regardless of differences, are treated fairly and with respect. Mr. Speaker, I close by saying I implore those of us in this House and outside of it to discuss their views freely but respectfully. At all times, we should keep in mind that those in our community who are in same-sex relationships or have family members who they love in such relationships are like us, made of flesh and blood, with feelings and emotions, and are not merely stone objects. Thank you, Mr. Speaker.
Call now on the member for East End.
Thank you, Mr. Speaker. Mr. Speaker, on the procedural matter, do you wish for me to move to beg that this motion be read under Section 12, of Standing Order 12?
Thank you, Mr. Speaker. If I may assist, the motion I moved asked for it to be treated as a private member's motion, so that would not be necessary.
Honorable member, all that is necessary is for the motion be distributed for members to have it, to have a copy, while I think just before you move.
Mr. Speaker, I beg to move a private member motion for the purpose of discussing a definite matter of urgent public importance.
So ordered. Honorable member from East End.
Thank you, Mr. Speaker.
Once it's read.
Mr. Speaker,
Yeah.
the motion reads, whereas the Chief Justice, the Honorable Anthony Smelly, delivered an executive summary of judgment in a civil matter brought by Chantel Day and Victor Baden-Bush as petitioners against the Governor of the Cayman Islands, the Deputy Registrar of the Cayman Islands Government Registry, and the Attorney General of the Cayman Islands as respondents, seeking redress through a judicial review on their rights to marry as a same-sex couple. And whereas the Chief Justice declared a change to the definition of marriage in the marriage law from, quote, marriage means the union between a man and a woman as husband and wife, unquote, to marriage mean, quote, marriage means the union between two people as one another's spouse, unquote. On grounds that the definition of marriage in law is as being between a man and a woman, while it is in conformity with Section 14.1 of the Bill of Rights, is not in conformity with the rights of the petitioners under Section 9 of the Bill of Rights to private and family life, and under Section 10 to their rights to freedom of conscience and freedom of expression of their belief in the institution of marriage by being allowed to marry, unquote. And whereas the Declaration has evoked extreme consternation throughout the Cayman Islands and the legal fraternity, and whereas it is believed by many that this ruling and declaration by the courts does not accord with the letter and intent of the Cayman Islands Constitution Order 2009, wherein the Chief Justice chose to ignore Section 23 of the Bill of Rights, which prescribes that if a law contravenes the Bill of Rights, a judge can make a declaration of compatibility but leave it to the legislature to amend the legislation. And whereas it is widely believed that by changing the definition of marriage in the marriage law, it effectively repealed both Section 14.1 and 23 of the Constitution enacted by the United Kingdom of Great Britain and Northern Ireland. And whereas if judges are left to arrogate unto themselves the authority to change laws based on their interpretation, this diminishes the supremacy of the Constitution and of the legislature to so do. And whereas the governor himself, a respondent, who enjoys unfettered responsibility for the appointment of the Attorney General, another respondent, all judges, including the judges of the Court of Appeal, has weighed in on the decision of the Chief Justice before a public pronouncement of whether or not the respondents will appeal interferes and possibly prejudices the right and ability of an appeal. Be it therefore resolved that this legislature record its support and recommendation for the government, that is the political directorate, to appeal the said ruling to the full extent of the appeal process on behalf of the people, to ensure that the tenets and the veracity of the Cayman Islands Constitution Order 2009 is upheld in accordance with the wishes of the people of the Cayman Islands. And be it further resolved that this legislature records its disappointment in the Chief Justice's and the Governor's lack of attention to lack of action to recognize or respect the doctrine of separation of powers that is enshrined in the Cayman Islands Constitution. And be it further resolved that this legislature asserts its competence under Section 59 of the Constitution of the Cayman Islands as the only institution with the power to enact legislation, and that such power can only be exercised through bills enacted by the legislature, either as principal legislation or by way of amendment.
The honorable member from Savannah. I don't think deliberate.
Thank you, Mr. Speaker. It is my distinct honor and privilege to second the most important private member's motion that will ever be debated in this legislative assembly. Thank you.
Motion has been moved. The resolved sections that this legislature recorded support and recommendation for the government to appeal the said ruling to the full extent of the appeal process on behalf of the people to ensure that the tenets and the veracity of the Cayman Islands Constitution Order 2009 is upheld in accordance with the wishes of the people of the Cayman Islands. And be it further resolved that this legislature records its disappointment in the Chief Justice's and Governor's lack of action to recognize and respect the doctrine of separation of powers that is enshrined in the Cayman Islands Constitution. And be it further resolved that this legislature asserts its competence under Section 59 of the Constitution of the Cayman Islands as the only institution with the power to enact legislation, and that such power can only be exercised through bills enacted by the legislature, either as principal legislation or by way of amendment. Honourable member from East End.
Thank you, Mr. Speaker. Mr. Speaker, just waiting on the young gentleman to bring me the podium. Mr. Speaker, the Honorable Premier, a few weeks ago, called on this country to be brave and bold going into the future with regards to making decisions on how we want the landscape to look. I say to the Premier and to this Honorable House and to my fellow Caymanians, those words were never truer spoken. Today is the day for the 19 duly elected members of this legislature to be bold and move forward. Mr. Speaker, I did not think this motion up with the intent of embarrassing anyone. To the contrary, Mr. Speaker, I brought this motion because I thought it was time to debate this matter and have it recorded the position of this country for current and future generations to come. That they will understand and appreciate what the people of this country believe and uphold. Mr. Speaker, regardless of my persuasions, there is a need to lay the record here and straight. It was brought, Mr. Speaker, so that each member of this chamber can express their individual views as representatives of the people of this country. Mr. Speaker, we are not here on our own. Many will answer that call. Few will be chosen. And the few that are chosen are chosen in faith by the people that they will govern them in the interests of their historical past and culture. Mr. Speaker, I encourage my colleagues today to take this opportunity to speak and let their voices be heard. Mr. Speaker, this real estate does not belong to me, or for that matter, to either one of us. Long before we came along, this real estate was here. Long before we came along, it was occupied by what the people thought and trusted to be their leaders. I just happened to occupy the real estate of EastEnders for the time being. Long after I'm gone, others will occupy it. This seat is an institution. And if it is disrespected, we, as leaders, must reassure the people of this country that we're putting it back on track. Mr. Speaker, this is not a political gimmick. As you said, sir, this is a serious matter. This matter, like the Premier said, extends beyond same-sex marriage. Mr. Speaker, when we negotiated the Constitution during the period 2008 and early 2009, I recall the difficulties that we had with that Bill of Rights, in particular, the Bill of Rights, the insertion of the Bill of Rights. Because England wanted one thing and we wanted the other. And like the Premier said, that is why we included the Seventh-day Adventists and the Cayman Ministers Association. Mr. Speaker, we fought many battles during those negotiations to ensure the Christian culture of this country was represented therein. We eventually prevailed, and we brought that back despite the opposition from some quarters and the support and the much support from other quarters. And we presented that to the people of this country. The people of this country believed us. And Mr. Speaker, I see 1, 2, 3, 4, 5, 6, at least 7 of us in here that participated in those talks. The people believed us then because we said to them, this is how your country is going to govern you. They took their leap of faith and went to the polls on the 20th day of May, 2009, and voted in the majority for the contents of this Constitution. And Mr. Speaker, I submit that those people, my people, this country, the people who were eligible to vote in 2009, took that leap of faith with trust that that is how the future was going to be governed. Included in that was the express written expression that marriage was between a man and a woman. Mr. Speaker, the Chief Justice said that somewhere in his executive that our reluctance is what caused him to go this way, because we wouldn't change it. Our reluctance to change it. Surprise, surprise. There was no reluctance on our part. That's what it was intended to be. Mr. Speaker, you were part of those talks, and so was the Minister for Education. So if you remove my good self and the Premier for a minute, who incidentally led the government into this, he got MBE for it too. If you remove he and I from this equation, the country need only look at the two of you, because it was the two of you who stand up fighting up in there with your Bible in your hand. Mr. Speaker, I said before, regardless of my persuasions on this matter, the law is the law. And that, Mr. Speaker, is what I will defend, because the people of East End, in particular, and the people of this country in general, expects me to uphold the Constitution that they voted for in 2009. Mr. Speaker, I voted for it, but I was only one person. There were many others. At that time, we were somewhere around 15,000 registered voters out of a population of some 50-odd thousand at the time. But those were the ones who were eligible too, you know. Only them can determine the future of this country. So when they decide that they want a particular person in here to represent them, it is our sworn duty to uphold their wishes. Mr. Speaker, this is not something that I trumped up this morning. The Constitution is very specific. And Mr. Speaker, we got to get to all of it today. Mr. Speaker, one of the provisions in the Constitution that has since not changed since 2009, that the people voted for, says, Section 59, there shall be a legislature of the Cayman Islands which shall consist of Her Majesty and a legislative assembly. Her Majesty is represented right there in the form of that mace. Subsection 2, subject to this Constitution, the legislature may, we don't have to, we do not have to, we may make laws for the peace, order, and good government of the Cayman Islands. Now, Mr. Speaker, when we receive this back from the drafters in England, we should understand that we are not the architects of this Constitution. The architects of this Constitution happens to be Her Majesty's government, and signed off by the Privy Council on behalf of Her Majesty. We are mere suggestors of insertions into the Constitution. And if there are areas that they do not want, they will not put it in the Constitution. A classic example at the time, Mr. Speaker, was that we proposed the governor no longer sits as president of the cabinet. We wanted the premier or chief minister, whatever we were going to get, to be chairing the cabinet with his ministers, his or her ministers. And they rejected it. They say they want their representative in there. You know who sits there as president now? The governor. That's how this works. So when they allowed us to put Section 14 into the law, which says, government shall respect the right of every unmarried man and woman of marriageable age as determined by law, the marriage law, freely to marry a person of the opposite sex and found a family, opposite sex. At the time, England was going through the same issues, but they allowed us to put it in ours. They allowed us to put it in ours. And the Chief Justice can say that we were reluctant to change it. There was no reluctance on our part. We had no intention of changing it. Mr. Speaker, I have the utmost respect for the Chief Justice. I want people to understand that, and I want the country to understand that. And the Premier say, we're all human beings. And so, too, is the Chief Justice. We all are prone to mistakes. Mr. Speaker, my only thoughts, my further thoughts on that is, as humans, we cannot set out with a predetermined outcome and go back and justify it. We can't do that. And I'm not saying that happened in this instance. But it is very familiar to that. We cannot do that. We are not in the business of second-guessing the wishes of the people of this country. If we are representatives and we don't know what they want, then we shouldn't be representatives. Mr. Speaker, and I go off here a little, digress here a little bit. A few days ago, one of the preachers called me in East End and said that they were getting together to discuss this matter, and if I could attend. Of course I can attend. Mr. Speaker, it must have been 9, 10, 11 them there when I got there. All of the senior ministers and junior ministers and the likes. Mr. Speaker, whilst those people did not have a good grasp on the technicalities that 18 years has taught me of being a member here, they understood. They nevertheless understood what was going on in the country. And I am to come here where they sent me, whether they voted for me or not. It matters not to me who voted for me. It just so happened I was first past the post. So I must come here and report to this honorable house, well, they say this, but I don't want to do that. Really? Is that how this works? No, it doesn't work that way. It doesn't work that way. I had a very healthy discussion with them, Mr. Speaker. And at the conclusion, one of my young cousins, who has been very quiet all her life, said she wanted them to gather as prayer warriors. Mr. Speaker, please don't crucify me for not understanding all the different things that we do in church. I'm God-fearing, but I don't go that many times. Mr. Speaker, all those women there came around me and laid their hands on me and prayed for me. Mr. Speaker, I can't tell you what got into my young cousin, but I can tell you she was seriously powerful in her delivery, something that I'd never seen in my cousin. And Pastor Mark was there with they too, and Oral and the legs. And the minister in East End, Blair, and many others. And Mr. Speaker, something came over me that I have never experienced before. Something, I have heard the expression divine intervention. I didn't know what it was until Monday night. Mr. Speaker, let me get back to the matter at hand. Mr. Speaker, when the Chief Justice ignored Section 23 of the Bill of Rights, which says that if in any legal proceeding primary legislation is found to be incompatible with this part, the court must make a declaration recording that the legislation is incompatible with the relevant section or sections of the Bill of Rights and the nature of that incompatibility. A declaration of incompatibility made under this subsection 1 shall not constitute repugnancy to this order and shall not affect the continuation in force and operation of the legislation or section or sections in question. In the event of a declaration of incompatibility made under subsection 1, the legislature shall decide how to remedy the incompatibility. Mr. Speaker, one of the things your good self, the Minister for Education, the member from Savannah in particular, who were here when I arrived, taught me is you see that building out there, you don't go out there and tell anybody what to do. That is the simple expression of the separation of powers. And if you go over there, you could be called in contempt of Parliament because you, Mr. Arden McLean, is now in the leadership role. Mr. Speaker, you taught me that, you know, to stay away from that building. Okay? Of course, my good friend that I came in here with, the premier may have understood that from his tenure as a law student, but he got a lesson in learning about it once after we got in here too. Stay away from it. However, I was also taught that it's not their place to come over here and tell us what to do. And many years of study, because I like to think of myself as a scholar of politics. Many years of study has taught me that the very people who elect you has enabled everybody else. They enable us to make the laws. We enable the cabinet. They're enabled by this legislature. It all comes back to this legislature. The appointment of judges are expressly outlined in this Constitution. Who was it who approved this? The people. So in essence, the judiciary is enabled by the people. And it's their money that pays them. So, however, that separation must be respected. And for those of us who does not know, and those who know from the outside, let me remind them the meaning of the separation of powers. Mr. Speaker, the doctrine of the separation of powers argues or dictates that when there are three arms of government, there are separate branches, each of whom have defined abilities to check the powers of the others. To check them. It's about balance. They each are independent of each other, but holds responsibility that crosses at some time. Mr. Speaker, this Constitution clearly defines how those separations are to be treated. It gives the judiciary the right to enforce the law, but when it finds that that law is in contravention of the rights of someone, because we're all human, then the judiciary must. Don't have the right, they must let us know. These hallowed halls. Mr. Speaker, the Chief Justice has failed in that regard. Now, Mr. Speaker, least someone says that I am here taking liberties and further eroding the line that is drawn between those separation of powers. Let me explain. Mr. Speaker, let me explain that what I have found, the Chief Justice ruling seems to be a stunning departure from what the courts have ruled in the past, as recent as 2013. In a judgment by Henderson, this is the law records. In 2013, J. and Ree Neram, 2013, 1C LR 345. He rules, our new Bill of Rights does not give to any judicial officer at any level the power to set aside any legislative provisions, even after a declaration of incompatibility. The impugned provision continues in force. The task of bringing primary legislation into compliance with the Bill of Rights is left to the legislature and not the courts. Now, that is Henderson, and remember Judge Henderson? Okay, good. Some may say that have their own opinions of him, but I'm referring to this one case. Mr. Speaker, he went on further to, in furtherance of that ruling and to justify that ruling, he referred to a Privy Council case in De Freitas versus the Agricultural Ministry Permanent Secretary in 1990, in which the Privy Council observed that an enactment construed by severing reading down or making implications into what legislature has actually said should take a form which it could reasonably be supported that Parliament intended to enact. The Privy Council in De Freitas quoted with approval from Osborne versus Canada Treasury Board 1082 DLR 4th at 347 to the effect that after wholesale reading down, a law may bear little resemblance to the law that Parliament passed, such as the case now, which gives rise to an interference that is simply incompatible. In such cases, the task of bringing the legislation into conformity with constitutional guarantees is best left to the legislative branch of government, as it will have access to relevant information and expertise not available to the courts. Now, Mr. Speaker, you tell me if the Privy Council can say that. What do I say about this one? Eh? I want to know, Mr. Speaker, you've been here longer than me, and you know more about it than me. But in my little time here, as I recall, one of the books that we should all read is The Legislative Process, written by Subumba, whatever his name is, Samamba, wherein it is explained the legislative process to get laws into place, enacted. It comes here as a bill. I'm starting from that point. We go through all the readings. Us, not them. Then we go through 2 readings, then we go through a committee stage where we can possibly change that bill. And then we go through the report back to the House, and then the 3rd reading, which is done. So we have approved it with the amendments at that stage or without. This Legislative Assembly administrative staff compiles that into vellum copy and sends it on to the Attorney General, who reviews it to see whether it conforms with the Constitution before he forwards it to the governor to sign it for enactment into law. Yeah. My good friend reminded me about the public consultation before, but I want to start at the here. Yeah. That's before we even get here. It takes years to get legislation in place. Now, the Attorney General is the only person authorized to give advice to the governor. I wonder how we gonna get this one in law. I want to know how we are going, the Chief Justice is going to get this one into law. He can't order nothing and no enactment. What about the consequences of changing one word in a law? It's the Attorney General who has access to that information so that he can ensure that it conforms with the Constitution. Now, this one can't conform with the Constitution. Do we understand now that the Chief Justice has no place to make law? He nor no one else. He is taking that right from the people who sent us here to do it. He has no authority to do it. Mr. Speaker, then we turn to the governor. And it matters not to me who occupies that position. Matters not. The fact is that that too is an institution which I must respect. Just like this. However, there's a human being in it, and we're prone to mistakes. Didn't we say that? Now, Mr. Speaker, I want to know, him being a respondent, why he come out here making such statement now too? And Mr. Speaker, I know my good friends over there may get up on a point of order because you know you got more lawyers over there than here. But I shall bring to their attention the standing orders which says this is a substantive motion. Mr. Speaker, 18 years gave me something, you know. Okay. Mr. Speaker, this man comes out here encouraging tolerance. Nobody has been troubled. The only people troubled has been the people of this country. And he talks about this judgment provides equal rights for everyone, a point which I and former governors had previously emphasized. Really? You think it bothers me what they emphasize? What bothers me is what the people emphasize. doesn't bother me. I have been here many years. Understand? I understand that I have spent more than I can hope to spend. But it's only those of me that I've been listening to. That's who I represent. The governor should also understand. And if he doesn't, I implore the Attorney General, who he takes legal advice from, to tell him that he makes up one part of the third arm of government, of governance in this country, and he must not cross those lines. Mr. Speaker, you know what happened with the last king that tried entering the House of Commons? They still mark the spot where he hit to chop off. That's a fact. Because of interference with the legislative way, the legislature, by the common people. What says? House of Commons, House of Commoners. This is the House of Commoners. This is the House of Commoners. That is why there is no educational prescription to come in here. The people decide who they want. That is why it's only $1,000 to register, because you cannot put it out of the reach of those of all others who would otherwise want to run. That's why it is. Has nothing to do with the governor down here. He come down here once a year and long may that continue. This is our house. This is ours. This is the people's house. This is their real estate. We enact what they tell us to enact. This has nothing to do with them. And if we are wrong, bring it back to us.
Honorable member.
Okay, sir.
Perhaps that's a good time to take our lunch. We will suspend proceedings until 2 p.m.
Thank you, Mr. Chairman, and your point is taken. What I would say in response is that we continue to work with the board along those lines to encourage the board and provide the necessary mechanisms to help the board to move to the point where all aspects of the matter would be open to the public's viewing.
Because the last time that I found it necessary to go to a CPA meeting, I was not allowed into the public aspect of the CPA until after. I don't know what went on, but until the board, until the CPA decided that yes, we started the meeting so the public can come in now. That is not what I believe is envisaged by the regulations and the need to have these things transparent, because I was very concerned that there were things going on in there that I should know about, but I wasn't being privileged to. And therefore there was a deliberate reason to keep me out. Is that the situation, in that each agenda, there are matters that are discussed before the meeting is open to the public?
Thank you, Mr. Chairman. I do recall the specific incident that you spoke about, and I'm happy to say that that prompted a change, so all aspects of the meeting are open. With the exception of the voting and the deliberation, as I said earlier. My apologies, sir.
It is the actual act of voting that it is necessary for the public to know if we are going to be able to clearly demonstrate that there are no corruptive practices occurring and that people are not being influenced to make a certain decision. So I trust that in the very near future, the actual decision making will also be a matter for public scrutiny. Another question is, do you have a way of in auditing whether somebody does in fact declare an interest in a matter before the CPA because of their registrar?
Thank you, Mr. Chairman. As I said earlier, the registers of interest are provided to me as Executive Secretary, and they're then